Good afternoon, everyone. Welcome to our second webinar of 2024, Towing, Xeriscaping, and Vegetable Gardens. Are we complying with the new laws? My name is Alina Gilbert. I will be presenting this joyous webinar today. And before I get started with all this wonderful information, I do have to go through my housekeeping, which again, for those of you who haven't memorized, feel free to tune out. For those of you who have not done one of our webinars before, in front of you, the bulk of your screen should be this PowerPoint and this wonderful meme. And you will see a small, kind of hopefully small box to the left of that. That's your presenter, me, hello. And on your right hand, you'll see an icon that says private chat. So that's what you use if you have questions as we go through this presentation. I will save questions for the end, so just type it in and we'll get to it towards the end, time allowing. If you're having any kind of problems with your audio or your video, before doing anything else, you will see a button at the bottom below the presentation and it says something like no audio or video ? Press that and it'll take you through a few steps that most of the time clears up whatever issues. But if not, then please reach out to our person who kind of helps me with these presentations on the back end, Jessa, and you can either email her at jledesma@altitude.law or call her directly at 303-991-2086. You will get 1 CMCA credit for attending this webinar, and it will be sent out within the next day or so once we have verification of your attendance, which means you have to stay on pretty much the whole time, whether you hate it or not. So otherwise, you will not be able to get the credit. You can't transfer your credit to anyone else. It's specific to you as an individual. And last but not least, if you have time, there will be a little survey that pops up as soon as this webinar is done. If you have time to click some buttons and provide some feedback, we would really appreciate it. It just helps us improve these presentations. It doesn't matter if your feedback is good, bad, or indifferent. It's just good for us to know. If there's something you want to see different, if there's something you hated, just let us know because we are always reviewing the feedback. So I am done with this part. So let's go into the information. And, you know, ironically, I originally was planning on splitting this webinar into 3 almost equal sections dealing with towing, vegetable gardens, and xeriscaping. And as it turns out, the bulk actually of our presentation will be on towing because there's just so many things to talk about when it comes to this towing statute. And the next second largest is going to be the gardening. And finally, the xeriscaping is going to have the least amount of time on it. But I just wanted to give you a heads up that it's not going to be split equally. So let's start talking about towing. So this is actually House Bill 22-1314, which was back in 2022. It's not a 23 bill, but it has significantly impacted, I think, the landscape of towing from community associations. The bill was, like the little summary of it was, this bill concerns the rights of a person with ownership interest in a vehicle that has been towed from private property without the person's consent. So again, the initial impetus was to protect vehicle owners from getting their vehicles improperly towed without proper, I don't know if you want to call it due process, or without a process in place to protect their interests. And this is not part of Kiowa. This is a statute, and I gave you the site right there. It actually applies to towing companies. It's not a statute that binds HOAs per se. And the question then becomes, well, why should we care about it as associations if it's not an HOA statute? Well, the kind of theme of this statute is the authorization and notice that's required for tows from private property. As you know, our property, HOA property, is typically considered private property, whether the association owns the common area or whether the association manages the common area or both. That's still considered private property. We're not public property. And so to that effect, this statute does impact us if we utilize towing as an enforcement means. So again, there's a specific requirement when it comes to authorization and notice for towing from private property, and the statute says that a towing carrier shall not non-consensually tow a vehicle from private property unless. So again, I'm emphasizing the towing carrier piece because to show yet again that this is not an HOA statute. And again, ask the question of, well, why do we care if this is all on the towing company? Well, the answer is because if, as a private property owner or HOA managing private property, we do not comply with the various requirements that we are going to talk about that are really requirements of the property owner, the towing company will not agree to tow, or at least they should not agree to tow, because then it's in violation of the statute. But even if we don't comply and a towing company, tows anyway, that still could be an exposure to liability for an association because we have not complied with the statute, and somebody could hypothetically make an argument that this HOA did not comply with all these requirements. And yes, the towing company was wrong to tow, but the HOA was wrong not to comply, and end up filing a lawsuit against both the association and the towing company. So we do care about this because it does impact us. It impacts our ability to tow, and it does still impact our exposure to liability on some level. Okay. So when is towing allowed by the towing company? So these are kind of the list of reasons that a towing company is allowed to tow vehicles. And this isn't limited to private property. This is any property. So one, vehicle is being repossessed. We as HOAs do not typically deal with that. We don't repossess vehicles, so that really doesn't apply to us. Removal is ordered by a court or by a peace officer. Again, that does not typically apply to us as association. Vehicle blocks access. Okay, so that's something that could come into play for an HOA property, and we will get into this in some more detail as we go along. Or owner of property or the association. The statute specifically says the owner of the property or an association created under Kiowa, so it does reference Kiowa here. So the owner or the association provides towing company with permission to tow within 24 hours immediately before the tow. And I think the reason that we see this 24 hours here is because there is a requirement, and this is a requirement on the property owner to provide 24 hours notice before towing. Okay. Now, it's not just, you must provide 24 hours written notice. There's some very specific things that the statute requires before, when it comes to the notice. Actually, before we go to the notice, I do want to point one thing out. I'm going to go back to the previous slide for just 1 second. So remember, this slide applies to when a towing company is allowed to tow. This has nothing to do with an association's ability to tow, because your ability to tow as an HOA is governed by the association's governing documents. And so in general, before your community decides it's going to start towing, or before you get a towing policy in place or something like that, you want to make sure that there's at least some broad authority, typically in your declaration, that's going to authorize the association to remove non-compliant vehicles. And, ideally, of course, it'll just say you can remove non-compliant vehicles. If you see that language, that's ideal. Sometimes it's not that clear. Sometimes you want to see something more broad, like self-help or the ability to remove items that are in violation of the rules. I mean, something on some level that we can link to the ability to tow. Please confer with your attorneys if you are not sure, or if you don't see a statement that says you can tow vehicles. Please be safe. Have the association's legal counsel take a look at your documents first and get you an opinion. It doesn't have to be a formal opinion, but an opinion as to whether or not you have authority as an HOA to remove a vehicle from the common elements that isn't parked properly. And just remember, the statute, Kiowa, doesn't specifically talk about the ability to tow, so there's no statutory right per se to do it. Okay, so again, the takeaway here is consult with legal counsel to make sure your community has the right to remove vehicles. Okay, now, before removing any vehicle, like I said, this statute requires 24-hour written notice that has to be placed on the windshield. Okay, so hypothetically, you place it on the driver's side window. That doesn't technically comply with the statute, and a towing operator could say, we're not going to tow because you don't have it on the windshield. Because remember, the towing operator also has a huge liability exposure here if it does not comply with the statute or ensure that the property owner has done what the property owner needs to do. So make sure that that notice is on the windshield. There are some very specific bullet points here. This comes right from that statute as to what you need to put in the notice. So you have to put that the vehicle will be towed if it remains parked inappropriately. You have to provide a description of why it's parked inappropriately. You're parked in a no parking zone. You're parked in someone else's parking spot. I mean, whatever it is, you are parked in 2 parking spots at once over the line. You need to describe what the violation is. You need to also provide in the notice when the vehicle is going to get towed if the parking job is not corrected or if the vehicle isn't moved. So statute requires at least 24 hours. So if it's going to be 24 hours, you need to put in vehicle will be towed in 24 hours. Now, keep in mind, some covenants have a wait period of like 72 hours before they allow towing. I've seen it. So you are not going to be able to have a shorter time frame than what your documents require. So make sure you take a look and see if you have any kind of verbiage to that effect in your documents. If it says 72 hours, 48 hours before towing, then you're going to have to do that, regardless of what the statute says. So the 24 hours is a minimum here. Okay. And then the other thing your notice must say is that if you continue parking in this inappropriate manner, the same inappropriate manner, you may be immediately towed, okay, in the future. So again, you need to make sure that your notices that go on the windshields have this information. A lot of towing companies, I've been told, will provide you with actual notices that you, as the community managers or as the board members, can just fill in and put on the windshield. But not all towing companies will do that. Okay, but just keep in mind these are the requirements. All right. Again, what does it mean for a vehicle to be parked inappropriately? Well, it means it violates the procedures necessary to obtain authorization to park. That's the first definition. So if you have a parking lot in your community that you need some sort of a permit to park, and someone parks there without a permit, it will be a violation because they didn't obtain the authorization to park. They did not park under the permit. If they fail to comply with the signage on the property, and we're going to talk about signage in a lot of detail here soon, because there's a lot that goes into this. Nothing's easy with a statute, nothing's quick or clear. So kind of keep in mind that signage is a big deal, and we are going to talk about that here. Or if a vehicle is parked in violation of a statute, rule, ordinance, or resolution of the state or political subdivision. Keep in mind, associations do not, for the most part, enforce local code or statutes. We are not law enforcement personnel. We don't typically have authority to do that. So this last provision really isn't going to apply. I know there's some communities that have verbiage in their documents that say, you know, you must park in accordance with local code. And so you try to enforce that. That's an extremely problematic provision to have in your documents or in your rules. I always recommend removing that if at all possible, because what happens is the association then becomes the law enforcement, code enforcement, something we're not really created to do. But if we're going to enforce codes and make sure the vehicles are parked in compliance with code, guess what? You got to know what the code is. You got to know exactly what it says. You have to know all provisions of it, and you have to know when it changes, because if you don't, you are technically in violation of your governing documents because you're not enforcing the code, because you don't know what it says. It's an extremely high burden to put on a board. It's an extremely high burden to put on a manager. These are not things that HOAs were intended to enforce. We're only intended to enforce our own rules, our own covenants, not what the state or the local municipality puts in effect. So if you have language in your declaration to that effect, talk to your legal counsel, the association's legal counsel, about the possibility of perhaps amending your declaration to remove it. If you have this language in your rules, generally the board can remove that without a homeowner vote. So take a look at that. We don't want you to be in the position of acting as a code enforcement entity. That's not your role, and it's far too much liability exposure for any volunteer board. All right. So let's move on. We are now going to talk about some signage. And like I said, there's a lot that goes into it. And there's going to be a few things that aren't on the slides that I'm going to want to talk about that you could take notes on. So, but first let's talk about what the slide says. So when it comes to signage, the statute specifically says, this is on the property owner, okay, that the property owner has to post signage that's visible to drivers at each entryway into the parking area. So associations typically will have at least 2 entrances and exits from their parking, sometimes more. You need to ensure that your entrances all have this required signage, obviously visible to drivers, so it's going to be facing where the drivers come in. That seems pretty commonsensical. Now, here's what the signage has to provide, and this is a little confusing. So it needs to provide that parking spaces are designated for parking spaces are designated for one or more specific residents, and a vehicle parked without authorization is subject to towing. And I know what's going through your minds. I think you guys are thinking, well, that's fine and dandy if we have assigned parking, but what if we don't have assigned parking? What if we have just rules that need to be enforced? Hold that thought. The sign must also say, or must have, the international towing symbol. And you guys have all seen it. It's that little symbol. It's got a picture of like the towing truck and the little car being towed. No smaller than 4 by 4 inches. And it has to be permanently mounted, no lower than 5 feet, nor higher than 8 feet from the ground. Oh my God, right? So I know a lot of you are thinking, holy cow, I need to go check if my signage has this information and if my signage is permanent and if it's appropriately height-based, right? Because honestly, What if it's 3.5, or what if it's 4.5 feet off the ground and not 5 feet? Are you gonna have to move it up? You might, because otherwise you're technically not in compliance with the law. So with respect to this first bullet point, that parking spaces are designated for one or more specific residents, and the vehicles parked without authorization are subject to towing. If you don't have this kind of system in place and it's an open parking, I would venture to say that you don't need that particular language. However, I can't guarantee it, because the way the statute is written, it specifically says you need to have a parking sign with this language. But it makes no sense to me to have this language if this language is absolutely inapplicable to our community. So I think if you don't have, like I said, assigned parking, I think you're okay to not have that specific provision in the signage. However, there is another section of this statute that talks about signage, but what the context is, it says a towing company cannot tow unless, okay? And so this is like a prohibition on the towing company, but all the things that have to happen really have to happen by the property owner. So the first thing is the parking regulations have to be provided to each driver when they enter the property, or notice of parking regulations. How do you provide your drivers, whether they're residents or guests, with notice of parking regulations when they enter the property? Well, most likely you are going to need to have some signage with those regulations on there. You know, you must park in designated parking spaces. You can't utilize more than one parking spot for one vehicle. We don't allow no oversized vehicles larger than whatever in the parking lot. You know, whatever rules you are currently utilizing when it comes to parking, you have to post them, because I don't know how else you're going to give notice of them to your drivers who are coming in. Now, the other thing, I suppose, that I've had people ask me is, well, can we just have like a box full of copies of the rules that people can grab as they pull in? I mean, I suppose technically you could. It seems very problematic to me, given weather conditions, given that you're going to have to keep track of when you run out and make sure you have them. But certainly you can try to get creative, but I'm just not sure how else you would provide notice. And then the other thing it says is there needs to be notice that any vehicle that is violating these rules or these policies is going to be subject to towing. So perhaps that's something that can all be on one sign, like this sign that we were just talking about with a little international towing signal. We could say that, okay, so if we don't have designated parking, then instead of that language, we can put the rules that we do have for parking, and then we'll say subject to towing. We'll have a little towing icon on there and say, you know, violators are subject to towing, and do it that way. That might be an okay way to do it. All right. The other thing to be aware of, as if this wasn't enough, we got more signage stuff. And this is not something that the association has to do. It's something that a towing provider has to do if they are contracted with an association or property owner to provide towing services. So some of you, I know, have contracts with specific towing companies. If you are doing that, the towing company actually has a requirement to post its own signage at your property. And I can't even get into like how specific this is. So it basically says that The sign has to be no less than 1 square foot in size. Okay. It has to have lettering that's not less than 1 inch in height. Has to have lettering that contrasts with the background on which the letters are placed. I mean, it just keeps getting progressively worse. There's a whole bunch of, I'm looking at a statute right now, there's just like a whole bunch of requirements. There's like 8 or 9 of them. So if you are, I'm only telling you this to make sure that if you are contracted with a towing provider, that you have had the towing company put that sign up in your community, because it is required under the statute to do that. Whew. This is a lot. I'm like tired of talking about signs. But I think we're just about done with the signage. But that was a lot of information. So please just make sure that your communities that are towing are in compliance with these, and that you do have these various signs, and that your towing provider does have its own signage. All right. Now, we talked about having to provide at least 24 hours written notice before towing. The statute does actually allow for immediate towing under certain circumstances. Now, I have taken out some of the criteria that doesn't apply to us, like things on public streets and things like that, and repos and whatever else. So I only have the instances here listed that would impact an association. So if a vehicle has received 2 previous notices for the same violation, 3rd time, they can be towed immediately without having to provide the additional notice. Next, vehicle blocks access to a driveway or a roadway. Remember, we mentioned this earlier. That allows for immediate towing, assuming, vehicles cannot get through. If someone is parked in a handicapped parking space without a placard, that also qualifies for immediate tow. Parked in a fire zone, so that's your fire lanes. Immediate towing. If you do have assigned parking spaces and somebody parks in a space that's not assigned to them, they can be immediately towed. And finally, no valid authorization displayed to park in an exclusive use lot. So again, if you guys have anything like permit parking and there's a vehicle parked without a permit, that actually allows you to immediately tow from the community. However, in the back of your mind, remember that you still have to have that signage we just talked about before you can tow. So you still have to have the signage in place saying, no parking here, or this is a fire zone, no parking, subject to towing, things like that. So you have to essentially show that we provided the driver of the vehicle with adequate notice that they were not allowed to either park here or they were not allowed to park here in this manner. So that's going to be really, I think, the key to all of this. And again, a lot of tow drivers now are getting very nervous about this, and they are, reviewing everything with a lot more scrutiny and saying no to towing if they feel like, hey, this doesn't comply with the requirements of the statute. Okay. By the way, I love this meme, all these little evil memes. Last but not least, be careful. Statute expressly prohibits towing for expired plates. So I know a lot of communities have rules or have something in their covenants that says you can't have expired plates. That's all well and good. Just keep in mind, if that is the only violation that the vehicle is guilty of, you cannot tow for that. There has to be something else, okay? Statute says you can't tow for expired plates. I'm not really sure what the impetus behind that one was, but that is what it says. So with that in mind, I have come to the end of the towing portion of this presentation, which took up half of our presentation. we will go, like I said, we'll go through the questions at the end because I want to make sure we can get through the rest of this stuff. And I see that there are tons of emails and questions coming in. So I suspect at the end, we may not be able to get through all of them. And you'll have my email address on there. So feel free to email me if you have additional questions or if we didn't get to yours. Let's talk about the right to garden. So this was last year's legislation. It was Senate Bill 23-178. And this is part of Kiowa. At least this gardening portion is. All right. So before we go anywhere, we need to make sure that you are all aware that this gardening right to garden is very important. Right to garden only applies to single family detached home communities. If you sit on the board or manage a community that's like townhomes with shared walls, condominiums with shared walls, anything like that, then you are not subject to this gardening portion of the xeriscaping. So just keep that in mind. And you can, I guess, tune out for this section if you'd like, although tune back in when we get to talk about xeriscaping. All right. So the statute defines a vegetable garden in an interesting way because it's a plot of ground or an elevated soil bed in which pollinator plants, flowers, or vegetables, or herbs, fruits, leafy greens, or other edible plants are cultivated. So technically, we're not really talking about a garden that only has vegetables, right? We can have flowers, we can have pollinating plants, we can have vegetables, we can have fruits. So ultimately, don't take this term vegetable garden literally. It's not literally a vegetable garden, it's a garden, okay? So what does it say? What does the statute say? It says, associations cannot prohibit vegetable gardens in the front yards, backyards, or side yards of an owner's property. And remember, this is your single family detached homes, most of which have yards, backyards, side yards, front yards, right? So we cannot, as a matter of course, prohibit people from having their vegetable gardens or gardens, if we want to say that. I think that's more accurate. We can regulate certain things when it comes to gardening, though. So what can we regulate? We can regulate the materials used to construct the garden enclosure. So if somebody wants to put a border around their garden or they want a raised garden bed that's surrounded, by something, we can regulate the materials that are going to be used for that enclosure. You can say it has to be, oak, it has to be whatever. We can regulate that. We can regulate the size of the garden. So be careful with that. Because remember, we can't prohibit it in these areas, but we can regulate the size. It is not reasonable to say that a garden may not exceed, 1 foot by 1 foot. I think we would all agree that is not reasonable. And in all our regulations, there is this standard of reasonableness, and that's what courts look at when rules, regulations, policies are challenged. Is it reasonable? In general, we did some digging, we looked around to see what an average size of a garden was, and I think it was anywhere from 8 by 8 to 10 by 10 feet. So in general, I probably would not recommend limiting the size of a garden to less than that. But you can do your own digging to see what you find as an average garden size. So I don't limit it, the size, to less than what you see as the average. You can limit or regulate the location of the garden within the front yard. So for example, you can say, the garden must be at least 5 feet back from the property line, or cannot be closer than 5 feet to the sidewalk or the driveway, or whatever seems appropriate. Again, remember, it has to be reasonable. If somebody has a front yard that's small and every piece of it abuts something, you're not going to be able to say, oh, you can't abut anything because there's no other way for them to do it. So you can't prohibit it without actually prohibiting it, right? You can't have the kind of rules that will essentially that will essentially have the effect of somebody not being able to put a garden in. You can prohibit interference with established fire buffers and defensible spaces if you live in a mountain community, or if you have you live close to a lot of open space, things like that. You can prohibit changes to the existing grading and drainage. And you can require approval for gardens, except pre-approved plans, which we will get to in a little bit. But you can require approval for gardens. Keep in mind, if you are requiring approval, you probably want to have something in place that has these regulations in there, so that if you are going to deny a garden, you have some legitimate reason that you can point to. And from your rules, written rules, that this violates our rules in that sense. It changes the grading. This interferes with our established fire buffers, whatever it is. But there's certain things you can't do. You can't regulate the plants that they're putting in the garden. And that's really the biggest thing that we got questions on when this first came about, is, well, can we tell them? The big one was, can we tell them they can't plant corn? People were terrified of corn because corn is tall, high. And a lot of board members, a lot of community managers were really worried that all these owners were going to go and plant and create these giant cornfields in their front yard. So the end result is you can't tell people what to plant or what they can and can't plant. That is truly up to the owner. And you also can't require them to have the garden be either in the front side or back. Or you can't say all gardens need to be in the backyard, because the statute says you have to allow them in these three places. So we can't tell them, no, you can't put it here. So again, we do have some controls over the garden, but not what's planted in the garden. All right. So let's talk about the pre-approved garden plans, because I said we were. And again, enjoy the meme, photosympathize. All right. So every single family detached home community must have these 3 pre-approved garden plans. These are actual plans that specify like the size, the dimensions, the type of plants that go in there, and they're pre-approved, which means homeowners can do them, can use these plans without having to go through approval through the board. Okay, you have to have at least 3 of them, and they have to be posted on your HOA website. Now, I've been asked a lot of times, well, can we just post a link? Can we just give them a website address that has these? No, you have to actually post the designs on your website, not links to them, not anything else, the actual designs. And you can have more than 3, but you can't have less than 3. Okay, but 3 is the magic number here. So the statute says you can obtain these designs from CSU Designable Garden Designs, which they do have. We've looked, they do have a page for that. You can obtain them from the municipality in which your community is located, or another entity that creates garden designs. So if there's like a landscaping company that has a website with, where you can download some garden designs or things like that. Okay, so you can do that. And if a homeowner chooses one of those 3 or more, designs that you have on your website, we cannot force them to go through the approval process. Anything outside of those 3, we can force them to go through the approval process. The other thing the statute says is owners must be allowed to have reasonable substitute plants if a particular plant is not available. Note the word reasonable. Everything's going to come down to reasonable. I know this provision made a lot of boards and managers nervous, because it was kind of like, well, what if the plant says cabbage and they plant a corn, some corn, And I would argue that that's not a reasonable substitute if it's not similar in how it looks, if it's not similar in size. I think it is extremely reasonable to say, no, you have not complied with the plan because, you know, it allowed lettuce and you planted tulips, or you planted corn, or you planted sunflowers. Those are not even remotely close to what the approved garden design had, and therefore you did not have a reasonable substitute, and you need to either remove it or go through the approval process for this other plant. Okay. Another thing that I really want to point out, because we get questions on this a lot as well, is a policy on gardening or xeriscaping or whatnot. I know that people get confused. They're like, well, do we have to have a policy on this? What does it look like? So the answer is this: you are not required by the statute to actually have a policy governing gardens, or xeriscaping for that matter. You are not required to have it. Keep in mind, even if you don't have a policy, you still have to have your 3 pre-approved plans posted on the website. There is no exception to that if you're a single family detached community. You have to have it. If right now you are sitting on the board of one of these communities, or you're managing one of these communities, and you do not have these 3 plans up on your website, you are technically in violation of Colorado law, and you are subject to liability exposure. Any homeowner can bring a legal action against the association for failing to comply with Colorado law and for breaching your fiduciary obligation to comply with the law, to act in the best interest of the community, yada, yada, yada. There's a lot of stuff out there. So please, if you don't have it yet, please make sure you download and post 3 plans, because it's very important. Also, with respect to the policy, you're not required, but if you don't have a policy, you really have very little basis upon which to review plans and deny plans. Because what would be the basis of denial if we don't have any guidelines or policy or anything in place that talks about what we expect and what is allowed and is not allowed with respect to gardening, right? So if you want to be able to regulate it, if you don't really care what people do, great. But if you want to be able to regulate it, then I would highly encourage you to at least, at a minimum, have some guidelines in place as to what's acceptable and not acceptable. Have your attorneys review it, just because the statute has a lot of confusing language and a lot of weird requirements, and we want to make sure your guidelines do not violate anything that's in here. All right. I am generally done with the gardening. Whew. And that was only 13 minutes. Okay. All right. Now we're going to talk about xeriscaping. Don't forget xeriscaping. We only have 1 slide. Xeriscape in and of itself is extremely complicated, and there just isn't enough time to go through everything, but I wanted to touch on the highlights of xeriscape. Now, a couple of things to keep in mind. Xeriscape, you have to allow it. You can't prohibit xeriscape. Where do you have to allow it? You have to allow it on the property that's maintained by an owner. Even if they don't own that property, like if it's a limited common element or a right-of-way tree lawn, if they maintain it, we have to allow xeriscaping in that property, even if, like I said, it's a limited common element. So this is not only applicable to your detached communities. This is applicable to all communities. Now, most of the time it won't apply to most condominium communities, especially stacked ones, but a lot of townhome communities, you know, that have little enclosed patio areas that homeowners maintain, it applies to them. Because remember, if a homeowner maintains the lawn, then or that property, then they can put in xeriscape, and you can't prohibit it. Okay, so that's important to remember. Don't worry about the right-of-ways. The associations really, if you recall, we had some legislation that said associations cannot regulate anything when it comes to public right-of-ways. So we can't really do anything about that anyway. So public, right-of-way tree lawns, if homeowners maintain them, yeah, we have no control over that. They can do whatever they want. We can't require they go through approvals or anything like that. We have to allow artificial turf in the rear yards. That is still a thing. And you can have rules or guidelines in place, specifically saying this is the type of artificial turf that's allowed, this brand, this type, whatever, this make, this model. You can do that, but you can't prohibit it. You also can't limit it. Like you can't have a rule that says no more than 20% of your rear yard may have artificial turf. You can't limit it. They can do their whole yard. Now you can require some sort of like a rock border like you would for any kind of landscaping, but you cannot really limit how much of the rear yard they put, either xeriscape or artificial turf. A couple of new things is you cannot require more than 20% hardscape on property. And remember, hardscape is non-vegetative materials. So, I'm no expert here, but, things like rocks, things like mulch, other decorative materials, but they're non-living materials. They don't require watering. So you can't require more than 20% hardscape on property, which to me seems weird because most of the time associations don't want a lot of hardscape. They want more vegetation, right? So I don't know kind of where this came from, but the flip side of it is you have to allow at least 80% drought tolerant vegetation on the property. Which means you can't say no more than like 30% of your xeriscaping may be drought tolerant vegetation. You have to allow for at least 80%. Again, it's odd because I think associations generally want more vegetation rather than less. So I'm not sure kind of what this is intended to do, but it says what it says. Finally, associations can adopt guidelines regulating the type, the number, and the placement of materials when it comes to xeriscaping. So again, you can have the guidelines that talk about these are the types of materials that are acceptable. These are the types that we recommend. This is how we want it placed. Again, you can't prohibit it, but you can certainly regulate that. And remember, when we talk, remember those 3 pre-approved plans? They only apply to gardens. They do not apply to xeriscape in general. So you don't have to have pre-approved xeriscape plans, only garden plans, which means all xeriscape can be submitted to the Association for Architectural Review. You can require that just like any other type of landscaping, okay? You can require all landscaping modifications other than the pre-approved gardens to be submitted to the Association for review and approval. So those are kind of the big ticket items on Xeriscape. There's certainly a lot more, and I'm not trying to make it sound like there isn't, but I think those are the high points. And I wanted, like I said, to leave time for us to go through some questions, and I hope 12 minutes will be enough. So I'm going to start at the top. And you guys can watch dancing chickens and pigs and all that fun stuff here. So let me just scroll up. There's a ton of questions. So again, I'm going to apologize ahead of time if we cannot get to all of them. First question is, do associations' governing documents supersede the towing law in certain aspects, like to the extent that if our governing documents require a longer notice than 24 hours, they will supersede. However, our documents cannot say, for example, you can immediately tow for an improperly parked vehicle, because we can only immediately tow under certain circumstances under the statute. So it really can't contradict most of it, but it can be more lenient than the statute. So again, really it's going to apply to primarily how much notice you give them, and whether or not the association has ability to tow, and also what kind of vehicles are allowed or not allowed in the community, because you can't create rules that conflict with your declaration. So those are the types of things that it's going to impact. What is the difference for towing companies who have permission to tow from pre-Cairo communities? There's absolutely no difference there at all. It doesn't matter. This applies to all private property. So it doesn't matter whether it's a common interest community, whether you're just a property owner, it applies to all the same. Can we give more than 24 hours notice? So the statute requires a minimum of 24 hours notice. So hypothetically, you can give more than 24 hours, and you absolutely have to give more than 24 hours notice if your documents, governing documents, require it. So this is just a clarification that the notice has to be on the windshield only, and a sticker on the driver's window, as an example, is not acceptable to meet this requirement. That is true. The statute is very clear. It says on the front windshield. So technically, you're not meeting the requirement if you're putting it on the side, or I mean on the side window. Can the towing policy be in the rules, or must it be in the CC&Rs? No, typically your towing policy is going to be a separate policy that references your parking rules. And it will just basically mirror the statute that says, you know, this is the notice we provide, this is how we're going to provide it, this is when we will tow immediately, that type of thing. You can make it part of your rules. It doesn't have to be a separate policy, but I think in most cases I'm seeing associations just adopt towing policies separately as opposed to making it part of the rules. In our complex, we have a rule that says you must move your vehicle every 10 days when it's parked in the common area. Is this legal? I think it's legal, assuming it doesn't conflict with anything in your declaration, but the hard part is really enforcing it. How do you know if someone's moved their vehicle? I mean, technically, if I get in my car, I start my car, I move my vehicle 10 inches forward or backwards, I've moved my vehicle, and now I've cured the violation. You got to start, you got to start the 10-day count all over again. So how are you monitoring that? That's, I think, the big question is, yeah, it's okay to have the rule, but is it realistic and is it feasible to truly monitor it? Okay, also, who can post the notice on the vehicle officially? It can be any representative of the association, whether it's your community manager, whether it's a board member, whether it's a committee member, as whatever. Another reason to perhaps have a towing policy is to clarify who's going to be doing all of that. So this is a practical question, a very good one. So when you're putting the notice up on the windshield, do you need the date and time that you place the notice on there? I would very much suggest that you have that. It's not part of the statute, but how are we going to know we gave someone 24 hours if we don't have the date, at least the date, right? So I think that is a great question, and I think it is an important point that you do want to have a record of when you actually placed that notice on someone's windshield. How do you handle vehicles that are parked in parking areas where signs state and designate the area as a snow storage area? Good question. So that doesn't seem to fit under any of the immediate towing options in the, I mean, it's not really blocking access to a driveway or a road. It's not, unless it's in a fire zone. I think you're probably going to have to do the notice instead. I don't think you're going to be able to immediately tow the way the statute is written. And that's my personal opinion. So I suspect there might be other attorneys out there who would tell you, no, go ahead and tow. But I just think reading the statute literally the way it's written, that is not valid reason to immediately tow. Sorry, some of these are just comments. Can you establish a policy for towing when it is not defined in the CC&Rs? Sometimes I think what you need to do is consult with your community's legal counsel first to make sure that your community has authority to tow. And if it does, then you can definitely have a policy on that, as long as it's not in violation of anything that is in your declaration. Does this hold true for HOAs that were created prior to Kiowa, so pre-1994? Yes, it applies to everyone the same. If there's a car parked inappropriately in another owner's spot and the owner wants the car towed, can the owner themselves call the tow? Does the 24-hour notice need to be provided still in this situation, or is the notice only required if the association calls to get the car towed? So this is an example of where immediate towing is authorized. If you have assigned parking and someone else parks in your spot that's assigned to you, you can call the towing company and request that the vehicle be towed immediately. Whether you are the owner, whether you are the association, you are not going to need to do the 24-hour notice in that case. All right. Sorry, my computer's being weird. Could you have a QR code? We had a couple of folks actually point out a QR code linked to the association's parking rules on the required sign. I mean, I think your guess is as good as mine. I think we could argue that that is a reasonable notification. Everyone has a cell phone. Everyone can scan a QR code, and they should be able to pull up the rules. I can't obviously guarantee that someone is going to, that a court would agree with us if it comes to that. But I do think it's a very reasonable thing to do, personally. Sorry, I apologize. My computer is not scrolling today. All right. I apologize. Okay. Could you, okay, we read that. What about booting a vehicle? So booting is not part of this statute. This is only towing. And there's a lot of communities that feel that booting is a better option than towing, because, you know, people are concerned sometimes, like, you know, if we tow a vehicle, what if somebody like left their medication in the car and they need it and they can't get it and then they die because they haven't taken their medication, God forbid, you know, what kind of liability exposure is that? And so I do have some communities that are very averse to towing, and they do utilize booting. And just keep in mind, the booting is not subject to this particular statute. I mean, it's not subject, it's not towing. It's a very different remedy. If there's no signed contract with a towing company, do we still need the sign? You would need the signage that I was talking about that the property owner has to put up, but I suspect then the towing company is not required to put up their own sign. Because remember, there was two kinds of signs, one by the property owner and one by the towing company. So the towing company sign, the way it was written, says if you have a contract with a towing company. So if you don't, I suspect you don't need that sign. Last question, and unfortunately we are going to be out of time. Is the entrance just to the parking area, or does it mean entrance to the community? For example, do you have to post signs on the entrance to the community and the entrances to the parking area? The statute says parking area, which sometimes is the same as entrance to the community and sometimes is not. So if you have separate entrances for parking, then I would put the signs there. It doesn't say into the community. All right, I apologize. We are out of time. I know there's a lot more questions and I'm very sorry, but please feel free to email them to me. There's my email address. And I'll do my best to try and get back to you with my answers. It may take me a little bit of time if there's a lot of you emailing me all at once. But thank you for joining us. Really appreciate it. And we will see you next time. Bye, everyone.